Lordship to when I come, I'd like to find out. I'd like to find out. I'm here on an entirely different. Now, yes. No, Lord, I'd like to find out, my Lord. Now here, my Lord, I am entirely, absolutely, my Lord, prepared to accept a negative order in all humility. In all humility, my Lord, see, your Lordship finds. My Lord, your Lordship finds. I'm here because I'm not humility. See, it's not that I'm infallible, but my Lord, on the conventions which I put forward, it is impossible to be lost. When I go before a court, and my Lord, I ask to myself 1,000 times, is there an answer to this question? If there is an answer to the question, I don't take a plea. If my Lord, questions are, if it is, suppose somebody is now it is midnight, the proposition, I only take up those conventions which has which cannot be contradicted at all, because these conventions are based on first principles, universal principles, first principles, universal principles. My Lord, I might I don't know, and my Lord, you are all students of law, and my Lord, now the doctrine of judicata applies. When they come for law, there is no stopper. There is no stopper. Yesterday, the doctrine of judicata comes. At least six conditions must be satisfied. One second. Let me complete it, my dear friend. We are not a bar. What will decide against me assuredly? Will you agitate or will you? Yes. My convention is, but all humility, my Lord, there is a great word, locus coini intentia. That is, locus coini intentia, my Lord, it's a time for repentance. I tell not before your Lordship, I tell the Supreme Court. I tell Justice demand at the time, it is time for repentance. Courts have made erroneous mistake, error, and that is human. Only one man ever claimed that I am infallible. Roma, Lopundayas, Nasa, Vinayas, that is both. Nobody has. The concept of judicata comes from Rome. Everything comes from Rome. The Gaius, Armenians, the Palestinians. I'm very honored. This court suppose I am before an MCD. This court cannot refer to another bench. If I am before a Supreme Court, then Supreme Court can say that the matter goes to another bench. If my convention is the record of a court does not bind everyone. Record of a court binds only parties. I am reading from the this is an American legal law and estoppel. I am reading one sentence. Yes. One second. Principle of estoppel. Let me see. It's not a question of being or losing. It's a question of doing the right thing. Yes, my Lord. Now, my Lord, yes. I take your Lordship. The definition. One second. Yes. Yeah, this is from estoppel of legal law. One sentence I am reading. One sentence. Of estoppel arising from legislative records, it is only necessary to say that the preclusion affects all the rules. There can be no such thing as individual parties to such records. All the peoples are parties, and all are therefore bound so long as the record remains unchanged. So, record of a court is binding only on the parties. Record of the parliament, and Thomas Fuller said, if I may, Thomas, record of a court is binding. Record of parliament is binding on all because we are all parties to the record of a court. We are all symbolically present in the parliament. Our assent is an actor, and that will bind. And the Lord may take your motion. is the record of the parliament. Fine sold. Transfer, I was not a party. It was not heard. I was not heard. None of us are heard. It is a decision which is rendered behind my back. I am not bound by it. It is always open to say, for me to say, pure on jurisprudence, It is always open to say, and my duty, my lord, if lawyers lose their spine, my lord, there is a, my lord, Jesus Christ said, ye are the salt of the earth. If the salt has lost its, where it shall be sharpened. Ye are the salt of the earth. If the salt has lost its savor, where it can be sharpened. If the lawyers, my lord, they have lost their spine. That is an unfortunate scenario today, fine. The lawyer has a duty to assert. I got just not down. I only know, in the whole of the world, I only know one person. And that person is my client. A man, he was representing, somebody was accused of being a traitor. So lawyer's duty cannot present the matter as effectively and forcefully as possible, fearlessly as possible. Displeasing the judge, yes, you have to. Displeasing the society, you have to. Suppose you are representing a rapist or somebody murderer, you will be displeasing society. Displeasing the client even, he may stab in the back. The client will stab you in the back. So therefore, the lawyer's duty, is no, transfer is contrary to the statute. It is an error. You don't follow an error. An error. Rare est humanum, rare est diabolicum. You cannot persist in error. Transfer is an absolute error. If I am in a public platform, I will say something more. Because in a court, I give due respect and therefore I am not using any strong expression. I only say it's an error. It's an error. What is coming to my mind is something else. I control myself. I don't say that. It's an error. What was issued before the Supreme Court in Transco? The question whether the notice under Section 32 is an action taken or not. The answer could be yes, it is an action taken or not. Yes. Transco, my duty to point. I went to the Supreme Court, argued the matter before Justice Nagareta. I said Transco is utterly erroneous, and this court has to decide. And the Supreme Court only sent me back to the High Court. I said the High Court will not listen to me. High Court has difficulty. Therefore, my lord, I am not expecting your lordship to decide in my favor. I am only expecting your lordship to regard my convention. This is what I convention. No, your lordship's order is greatest of humility, your lordship's order has not exactly or not fairly regarded what my convention is. My convention is universal principle. My convention is, my lord, the doctrine of judicata mandates all parties, all causes, all controversies be brought before one forum and this decision, right or wrong, be binding. And, my lord, the duty of the court to apply the law. A party, my lord, really CPC, order 6 CPC. In Esteban's case, the one which your lordship said explained the other day. Here also I have went to the Supreme Court. Here also I have page 92. Page 92 please. Page 92. What I am asking for, follow CPC. Order on rule on CPC. Order on rule to CPC. Yes, Article 32 petition. Yes. However, the petition shall be liberty to raise all their contentions before the tribunal High Court where the case is still said to be pending. So, my lord, I am raising a pure question of law. Which case is pending when this order was passed? My lord, the court only said it was pending. My lord, whether it is, this is an issue which has never been decided. My lord, there is no estoppel against law, but I am willing to accept that if your lordship decide against me, I will not commit again. That is out of basic Maryada. I will not trouble your lordship again. I am here before your lordship because it's a different party. This man is entitled to, my client, who may stab me in the back, he is entitled to, my lord, a decision on the merits of the case. And what I ask for is, my lord, here somebody says, yes, I am not going to the facts of the case. But since the reference has come about the notification, I did not read the notification. The law need not be pleaded. Lex Kuriad Novit. Court is presumed to know the law. And my lord, CPC, order 6, rule 6 CPC, that you don't have to plead law. May I take your lordship to? Yes. Yes. Yes, my lord.
Action against the dead person.
What is the date of the judgment? That is subsequent matter was not listed. This contention was not there. My lord, this issue. My memory is right, but I'm slowly aging. My memory is right. I came before your lordship and said the Supreme Court has passed a direction like that I may be here. And your lordship said no. I went back. What is the contention that you raised? No, I said, my lord, the proceedings under this MSME Act is without jurisdiction, barred by the first clause of Section 19 of the Recovery of Debts and Bankruptcy Act. And on the merits that I am protected by the MSME notification, and it is the duty of the court to apply the law. There, my lord, I rely on CPC. Pleadings. My lord, I take your lordship to order 6, rule 1 CPC. CPC, my lord.
Because then you file a counter on this. His contention here is because he says he is this was the contention raised in this SLP.
Repetition.
That's true, but then take page 9 to paragraph 2. Because as far as your MSME contention is concerned, I will not consider that.
No, my lord, with all humility, my lord, take your lordships. Now there is a judgment of the Madurai High Court. I am not relying on judgment, but my lord, my lord, I take your lordship to Madurai. See, I am dead against judgments. Because my lord, these two, it doesn't no longer serve any purpose. Earlier it used to serve a purpose with thousands and thousands, millions of judgments every day being churned out. It lost all its purpose. But I rely because my friend is, most people are so much fond of judgment. Therefore, I take your lordship to the judgment. May I take your lordship to para 10, Madras High Court. So the Madras High Court has said repeatedly coming before the court and not have raised the issue of MSME will not stand as an estoppel. And Madras High Court has also rejected the plea that you have to go to the DRT. There, the Madras High Court has not explained the reasons. In my case, I said the MSME Act, insofar as creates certain rights and obligations in my favor, rights in my favor and obligations against the bank, has not created a forum for the enforcement of such rights. The jurisdiction of the civil court is not outset. DRT has no jurisdiction to go into those aspects. And the Madras High Court said in one way that DRT has no jurisdiction. And secondly, Madras High Court has said there is no estoppel against law. I take your lordship to I very briefly take your lordship to paragraph 10. Paragraph 10, yes. The primary contention raised by the petitioner is that the petitioner, being MSME unit, is entitled to the framework, etc. But the contention of the respondent is that when the section 13 notice was issued, the petitioner did not bring it to the knowledge of the petitioner is an MSME and entitled to the benefit of the notification dated so and so. My case, it's a MSME loan. The convention of the bank cannot be accepted since at the time of processing the loan document itself, it would have declared, it would have noticed maybe the unit comes under the MSME. It is pertinent to state when the MSME certificate is issued to the...
As far as MSME is concerned, I simply say that you are covered by the earlier judgment of mine.
No, Lordship may say so, but after hearing me, my lord. May I quote a Latin maxim about your Lordship's permission for Dr. Judicata to apply. This is I am quoting from Ulpian. My lord, yes. Yeah. Si omnia sunt idem corpus, idem quantitas, idem just, right? No, idem just, idem cosa petendi, idem conditio persanarum, idem conditio persanarum. These things should be complete. All this should come. Then only the doctor can apply.
In fact, even that is considered by me.
Everest
You
will stop
argued
it.
the restricted
No. Therefore, the question is, what the Madras High Court has said, Madras High Court has said, take your lordship to the, yes.
You did argue restricted in the earlier round.
No, judicata to apply, judicata to apply, all these conditions should be satisfied.
For that, you relied on 2018 judgment of the Supreme Court cases that in its judgment.
Yes.
With that also.
Yes, but can you give the Everest? I give my mark because I'll give the unmarked to mark copy. I can easily trace it. I think it is a mark copy. Yes. At page Malone 77. Yes, 77. I got it. Page 77. Yes, the principle upon which the defense of res judicata depends is as follows: the modebit bis vexari pro uno et illam causa. And in criminal matters, the modebit bis puni pro uno delicto. The same principle applies in equity. Thus, it has been held that after issue is joined, publication pass, and the cause heard on the same matter on the same date, it could not be drawn in the question in another original bill. Conditions necessary for the validity of the defense are stated by the civilian, exceptio re judicata non edita gendi obstat, quamsi idem questio, inter idem personas reversit, icate idem damnum noset si omnia sunt idem corpus, idem quantitas, idem just, idem causa petendi, idem que conditio persanarum. And my lord, there's this book I hand over to your lordships. Actually, this book is more elaborate. This, my lord, bigger law. I don't have a extra book with me, and most of the areas I'm marking. So, I don't have a copy of that. Yes. So, my lord, the doctrine of res judicata can apply only if there is an adjudication on facts. The question whether I'm entitled to or not, whether I'm MSME, I'm entitled to, has never been decided. Once your lordship says, I'm an MSME, but your lordship decides that I'm not an MSME, I'm not entitled.
No, even at the earlier round, I told you, if those conditions were coming for the first time,
yes.
certainly I would have
No, the custom, now they take your lordship to the Madurai bench has said, paragraph 11, my lord. Paragraph 11. Not that if they have constituted one committee if any bank or financial institution in this country has constituted one committee and given the benefit to one borrower, I will withdraw the case. Not by hang me tomorrow, but I will withdraw the case.
Matthew,
yes.
one case which I rendered in the PDMC,
Yeah.
South Indian Bank.
Yes.
In the judgment.
Yes, your lordship, yes. But my lord,
watched the notices,
yes.
directed reconsideration by the committee.
Yes.
Why do you say that it's not being?
No. The bank on their own. They came to the bank their own. It was my case was filed by me. It was filed by me because somebody said I don't have a face value. Some other lawyer was engaged.
You were in the first round.
I was there. Then somebody said that my equation the next date is not that comfortable. They changed it. Yeah. Okay. Yes. No, my lord, the problem is, my lord, now the litigants would say, because Matthew Nandamba took up the brief, MSME's case was denied. That they are saying so. Yes, I will not say so. Yes. No, my lord, now the question is, my lord, how much it has been, what kind of exercise has been done to say no to a claim which is as undeniable as daylight. Your lordship will find Justice Bechikurian Thomas took up the issue of what is the game, what is the Canara Bank, what is the name of that case? Korak Mahendra. I told Justice Kurian Thomas 10 times that has nothing to do. This is a case between the rights of between a borrower and a banker. There the dispute is between between two creditors. How many times I will explain it till the same thing comes. There is absolutely no. Yes. Lord, I must say, a spade has to be called a spade. It is displeasing to many, but a spade has to be called a spade. And at the age of 67, I don't fear to say a spade is spade. Spade is a lawyer has to call a spade a spade.
Mr. Matthew, will you please listen to me
Yes,
for 2
yes.
minutes? When you argue PDMC in the first round, the law enforces pronouns.
Law is not notification. Notification. Product is only an interpretation. Product is an interpretation.
Interpretation.
See, what is a record of the court? What is a record which is binding is the record of a parliament, not the court. It is against the basic principles, against principles of natural justice. How am I bound by a judgment in somebody's case where I was not heard? Here in this country, PALs are conducted not PAL, if at all, can be conducted as a representative proceedings. You strike down, reduce the parliament to an inferior tribunal, and there is no lawyer in this country to say that in the open, because many people profit by that. Reducing the parliament to an inferior tribunal. Judicial review is different, my lord. These are all things somebody should speak.
Mr. Matthew,
Yes.
please listen for 2 minutes
Yes,
and
yes.
then you answer.
Yes.
The pronoun said, right or wrong, it said in paragraph 17 that once you don't raise it at the stage of 32 reply, then you are not entitled. It is what pronouns held. Thereafter, Justice Deepankar's judgment came. It said even if you take
Can you call it a judgment, my lord? A judgment is where swords are crossed, battlefield and drawn. You issue. No, 1 second. My lord, a lawyer has the freedom. Lawyer should be fearless. Fearless. How a judgment is drawn, my lord? When you issue notice, you hear the parties, then a judgment is drawn. It is all, my lord, in Roma, Locuta, yes, that is what you call, my lord, ex cathedra statement. The Pope used to issue ex cathedra statement without hearing anybody. Even Pope used to hear ex cathedra statements. That is, then the Pope said, I am infallible because I was protected by Holy Spirit from coming here. So therefore, Divanka Datta's judgment, I only appealed. In that matter, Divanka Datta's judgment is no judgment.
Therefore, you are supposed to know.
No, I know it. What Divanka Datta, Justice Divanka Datta did, you would not allow me to dictate the order, and he kept pronounced the order in the chamber. No such order can be pronounced in the chamber. The order has to be pronounced in the open court. Open court. Every judicial pronouncement has to be in the open court. That is not a judgment. The battle lines are not drawn. Swords are not crossed. Without hearing anybody. It is like that Satyajit Tandon. Nobody was there. Then the Supreme Court writes 30 pages of judgment.
No, but that judgment is in your favor.
I am not interested in whether in my favor or against me. I am, my lord, there is your lordship, my lord. I have somebody embarked upon a larger goal of doing justice to the country or the society as a lord. I suffered enough for a pursuit. I have a larger goal. I have a passion for doing something good for the society at large. Not winning a case for one case or not. Winning and losing a case is irrelevant, my lord.
Mr. Matthew,
Yes.
only trying to tell you that this is in law. Because earlier pronoun said, if you don't raise contention of this stage 32, you are out. Which stands changed by the second judgment of Justice Deepankar. It said, even if you raise it as a defense, in a reply to 32 notice, you are entitled. It is on that basis that I said in PDMC. Therefore, that client had raised this question by way of an answer to the 32 notice. Therefore, the bank was enjoined to comply with the notification.
The same happened in Estepan. Estepan was denied, dismissed. Your lordship's only dismissed. Estepan in 13 to reply. He brought to the notice, yes.
Sorry, Estepan, before me, your argument was only on the basis of transfer.
Yes, sorry. Sometimes I may not this loss. Yes,
Not
it
sometimes you're-
was
you're
dismissed
getting
by,
facts wrong.
dismissed by.
Justice Gopinath.
Yes, Justice Gopinath. So, my lord, yes, my lord, the same petition is coming because I told the Supreme Court openly, Justice Khanna, your lordship may dismiss 1,000 times. If there is a litigant, I will come on the 1,001st time. There is no question of, if you are convinced that there is justice on what you say, what you write, and unless you get a convincing reason, then the other person I will not stop. Because there is something called, it is said, drops of water. My power is of that of a drops of water, and I am powerless. Drops of water can hollow a stone, not by its force, persistence. You keep.
You will keep on arguing
Yes.
till they hold in your favor.
No, my lord.
You will keep on arguing till they hold in your favor.
No, till it is right is decided. No,
For that,
a judge decides against me. If there's a good reason, I'll worship the judge.
No.
Why worship? There are good judges. My lord. Come to justice. Come to Bombay High Court. Justice Vasipta, gem of a man. It's difficult to believe such men are there with the blood and marrow. Justice Vasipta, gem of a man. To say how dignified he treats the litigants. Some judges, when a litigant says, take 5 steps back to the litigant, and Justice Vasipta would so kindly, so considerate, just like that Caprio, that Caprio is the American judge, like that. There are judges like that, and then we worship. So, my lord, the judicial function is always divine. Cicero said, I forgot the Latin word, I forgot it. Nothing in men do come closer to divinity than delivering to their fellow men. Nothing in men do come closer to divinity than delivering. Therefore, your lordship exercises a divine function. And my lord, for me as a lawyer also in that process, servant of justice. It is immaterial whether I win or lose. Nothing. Yes.
You argue with this proceeding.
Yes.
You argue.
Yes.
Your conduct is dealt by a court, and the repetition is dismissed. What are you supposed to do?
No, my lord, res judicata, if it's a pure question of law, res judicata doesn't see if I am entitled to something in law. If a parliament has ordained, the record of the parliament will remain, and not of the court.
That is on your argument, not the provision.
No, my lord. Anything, that is why, the court judges can decide wrongly. But that is on facts. A court can say 1 + 1, 0. That is what my lord Woodley has said. Res judicata facit. Ex albo negrum. A judicial decision on facts can make what was white black. Ex negro album, what was black white. Ex recto album, what was straight curve. Ex curvo rectum, what was curve straight. So a court can, facts say 1 + 1 is 0.
Where is the finding of res judicata in the Madurai judgment?
No, my lord, yes, I take your lordship, my lord. Your lordship may permit me to read 2, 3, 4 sentences from this statement as literally as possible. Paragraph 11. No, paragraph 11 I am coming. Paragraph 11, one word only, my lord. In fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 or the framework, etc., it was admitted that no such committee was formed. The relevant portion of the clause is extracted here under, yes. Then coming down, the above clause specifically states the bank shall constitute one or more committees. But the bank failed to constitute such committee. The bank has not constituted one committee in respect of one borrower in this country. What is the name of this bank? Our bank? South Indian Bank. If South Indian Bank has constituted one committee, when Parliament enacted a law and you throw it to the dustbin, there is no need for me to plead law.
Come to para 13.
I'm coming to that. Yes. The bank has raised the plea that present petition is hit by the principles of res judicata. At the same time, it has also stated that the petitioner for the first time has raised the plea of the benefits under the 2015 notification. The court is of the considered opinion that when the issue was not raised in the earlier writ petition and it is raised for the first time in the present writ petition, then there is no question of res judicata at all. Further, there is no, in none of the Indian judgment, there is no detailed discussion about the doctrine of res judicata at all. Unfortunately, we have judgments holding that 2014-2006 judgment of the Mundapadiyar case that the dam is safe and the dam breaks, Mullaperia breaks, the water will go exactly follow the dictate of the Supreme Court judgment and run through the Periyar River and reach Idiki Dam. And that 5-judge constitutional bench in the Supreme Court, as Harish Salve argued, has held that that judgment is binding in the whom, binding on whom I do not know, as res judicata. So that is erroneous. These are the judgments on res judicata in this country. There are no good judgments on res judicata. So therefore, yes, I have researched a lot of judgment. There is no discussion. There is no meaningful discussion, any elaboration on the doctrine of res judicata in any judgment. And whatever is little bit there is often contrary to the propositions. My Lord, I read this one sentence, my Lord, and therefore no discussion. Therefore, there is no discussion about 2015 notification at all. Therefore, the plea of res judicata by the bank is rejected. So, res judicata pro veritate accipitat, it's a policy. It's a policy. What my Lord, res judicata, what contemplates is treat something untruth as truth. And that serves a larger purpose in the interest of public in the public interest. So res judicata, the intention of the concept of res judicata is to allow untruth to prevail, injustice to prevail. No, the sole purpose is interesto republico utsit finitium. It is in the interest of the Republic that there is finality of the litigation. Therefore, res judicata pro veritate accipitat. Therefore, Roman lawyers say judicium semper pro veritate accipitat. Semper means always judicium. What is judicium? Is always treated as truth. It's a presumption.
Now, Sunil, as far as this contention is concerned, which was never raised in the earlier rounds of claiming the benefit of proviso 19 by this petitioner. And the Supreme Court order, page 92. That is it, but this was not the issue there. Correct. This petition only focuses on 19 and 13 dead.
No, one word of interruption. I'm relying on, not that I'm relying on judgments, but relying on a 5-judge constitutional bench of 1963. Experience shows that petitions filed under High Court under Article 226, which raise arguable issues of much less significance and importance. Rule nisi is usually issued, and speaking broadly, there seems to be no justification for holding that in a case which undoubtedly raises questions of considerable importance, that court should not be adopted. Issue notice, but not let the government of India come and state an affidavit. Let the
Union a party here.
Union of India is party, yes, but no, absolutely. Yes, absolutely. Yes.
Now, who is appearing for the Reserve Bank?
Let notice be issued, my lord. Union of India is a Reserve Bank of India, Board of Directors South Indian Bank. Yes, Ministry of. One second. The court has asked me. Response number 6. Union of India represented by the.
Take notice for 4 to 4. Notice by speed post to respondent 1. Appears for respondents 4 to 4. Who is appearing for the Ministry of Micro Small? Respondent 5 and 6. DSG appearing.
ACG.
6. Yes. CGC. Respondent 5 and 6. DGG appears for respondent 5 and 6. Non-pleader appears for the. Have you got a copy? Non-pleader appears for the 7th respondent. Who is 8 and 8? Notice to the 8th respondent disconspicuous.
9th also, my lord, in that case.
9th has nothing to do with this. 8th and 9th. Notice to the 8th and 9th dispense. File a counter. Whereas respondents to file a counter. 2 weeks.
The State Bank of India actually has been given the de facto leader of the other banks. And my lord, status quo to be maintained, my lord. Status quo to be maintained.
What is the stage of recovery?
My lord, this was filed, my lord, this was
30th of?
This petition was filed a week before that, my lord, because when
Now what happened to that?
well, that has been adjourned, my lord, because of pendency of from January onwards. But we are filing a petition to you.
I'll give you 2 weeks time for filing a counter. Nothing will happen. The
In the middle, Lordship,
orders are not passed on.
my lord, it has to be, my lord, MSME will have to be granted relief. There is no way out. Can we deny it is daylight? Impossible.
The previous judgment, my lord, had
Impossible, my lord. It is affecting 1 crore people. Nothing, no damage is caused. You consider a committee, give some relief. Give an exporter.
We'll file it next week.
My lord, your lordship may grant and relief mean status quo to be maintained by both parties.
I only record their submission. The application. Pending consideration.
the aggregate commission had been appointed, my lord. In fact, the
You said it's pending before the magistrate court.
correct, my lord, the thing is pending, my lord. So they have not taken physical question. In fact, one was property, property factor from this property had already been taken physical question.
Don't do that till 15th, till 22nd.
I shall, my lord,
Status quo by both
my lord,
parties.
may not
Status quo by both parties.
Nothing happens till pending.
Vacation court has passed an order status quo by both parties.
Where is that order?
Yes.
Where is that
Yes,
order?
the pan.
You're mixing up every case.
Eh?
You're mixing up all cases.
No, my lord, one case would have been withdrawn by
In fact,
part.
my lordship, I would mention.
No, my lord, I just who is afraid of cost? Banks will have to be. If I am a judge of the Supreme Court, I would have held them responsible. This issue will not be.
That judgment was to prevent the court from passing an order.
That did not happen.
No, my lord.
The 32, they did not identify. They said the High Court will consider all these cases.
You don't have a copy, my lord, of what this.
What is the order? This is the order, my lord. The status quo by both parties. I think that should be better.
That's in a different case.
No, I'm not. I'm saying similar orders. It is no way binding. It is no way processing. Nothing. I simply said.
20 seconds.
I am for the petition, my lord.
As per the respondent grant, your lordship, the total outstanding is 32,61,000, your lordship.
Period is over.
No, your
No.
lordship, it is 11 years
What
and 2
defaulted
months is
amount,
left.
OD amount?
Upgradation amount is 2,25,000, your lordship.
2,25,000.
Yes, your lordship.
8 installs. Make OD amount. Pay 75,000 in 1 month. Balance 8 installs. Balance in 5 installs.
Along with regular EMI.
Good. The petition is personal property were attached for the liability of the company. That is the question. Not personal property of the